Prosecutor's Office, and the Chief of the Appellate Section, Jason Williams, is to my immediate right. This is going to be a little lengthy, and I want to start off by saying that I'm going to reference a couple of rules of professional ethics that relate to prosecutors. And the first one is Michigan Rule of Professional Responsibility 3.6 that deals with trial publicity. And I'll let you read it for yourself, and I think it's been indicated to you that we are going to provide this PowerPoint to you electronically after today's press conference, so you can read the rule. But as prosecutors, we do not try our cases in the media. Our statements are governed by our professional rules of ethics and the interests of justice for our community. It is our duty to follow these rules and follow the evidence and argue the evidence in court. And I have listened to years and years of things that have been reported, and we cannot even respond if we want to be with our ethical rules. So there's all kinds of information about this case that's out there that's inaccurate, and it's our attempt to walk you through that today. Second rule I want to reference is Rule 3.8. It deals with the special responsibilities as a prosecutor. Prosecutors have duties that are different from anyone else in the criminal justice system, and we also have a duty to the community that we serve when the evidence comes to light, or when any evidence comes to light that calls a conviction into question, and we must disclose and investigate that evidence. We do not just get a letter or anything else and just dismiss or change a case based on that. We go with evidence that's here in court, and again, we do a full investigation. To do anything else would be irresponsible. Continuing with Rule 3.8, we received evidence on, or information I should say, on the 20th of May of this year that called into question the murder conviction of Davontae Sanford. The evidence was a culmination of an investigation done by the Michigan State Police and was promptly turned over to the defense. That was 20 days ago. Now let's go back. On May the 4th of 2015, last year, I requested that MSP undertake an investigation, Michigan State Police, undertake an investigation into the Davontae Sanford case. This request came after years of post-conviction hearings and appeals. We made that request. Not anybody else, we did. We're going to talk about a timeline now as we go through my remarks today. And let's start off with the fact, and you probably know this case began in 2007 and has been litigated almost continuously since then. There are people that have perpetuated the myth that somehow we found out about evidence in an earlier year and nothing happened until just recently. But again, this case has been litigated almost continuously since it occurred. I'm going to walk you through now, through the timeline, to show you how this case unfolded and show you how the new information from the Michigan State Police led us to the conclusion that the interests of justice required that Mr. Sanford's conviction be set aside. Throughout the years, press articles and court filings, it's important to remember that this case is about the murder of 4 people. And anything that we see reported in the media never talks about the victims in this case and the fact that 4 people lost their lives in September of 2007. 4 people were shot to death, 1 survived multiple gunshot wounds, and a child escaped the shootings physically unscathed. This is 19741 Runyon Street in Detroit, where 6 people were inside that night. Pages sticking together. This is Brian Dixon. He was age 31. He died of multiple gunshot wounds. This is Michael Robinson, age 33, also died of multiple gunshot wounds. This is Nicole Chapman, age 29 at the time, also died of multiple gunshot wounds. And this is D'Angelo McNorial, age 31, also died of multiple gunshot wounds. So please let's never forget that this case is about them and the fact that they lost their lives. These killings occurred on Runyon Street on the east side of Detroit, as I said. The evidence showed that at least 2 guns were fired from outside of the house through the front door into the front room, which was occupied by the adults who were in the house at the time, so at least 2 shooters. There was firearms evidence that from at least one gun, a 7.62 x 39 rifle, and a .45 caliber handgun. So at least 2 weapons, maybe more. At least 2 shooters, maybe more. This photograph shows fired casings, or the fired casings that were found on the front lawn of this address. The front porch is at the left side of the picture. This next photograph shows the picture of the car from the driveway from the previous photograph. In the corner of the house, it can be seen at the top right of this picture. Of course, those numerical placards show where fire casings were found. This is the security front door of the house, or the security door of the house, which shows the bullet damage, some bullet damage. And this is the front door showing the damage made by the bullets going through the front door. The shattered glass from the door can be seen on the floor. This is the bed in a back bedroom. A 5th victim, a female, was hit 5 times. She survived. She ran from this bedroom, from the front room of the house into this bedroom. There was a child who was sleeping in this room, and the woman that was hit, or the victim that was hit 5 times, hid under the bed. While she was hiding under the bed, she had a brief conversation with one of the assailants that had come into the house. He wanted to know where the valuables were, and she denied knowing where they were. She would identify the voice of this person as being Davontae Sanford under oath at trial. Further, an off-duty Detroit Police Department chaplain lived down the street from this address where these shootings took place. He heard the shots, and he saw figures running from Runyon in the direction of State Fair. These figures noticed him, and shots were exchanged across Runyon. The casings from the gun fired at the chaplain matched the casings at the scene of the homicides. These pictures, the next picture shows, this shows the path. Can we show that? Okay. The next picture shows the damage to the chaplain's home from the incoming fire. I got slightly ahead of myself there. See the damage there. Dog track evidence. The Detroit Police Department requested a dog to respond to the scene to track scent evidence. The dog track, and we'll show you, picked up from the scene of the second shooting, that's the chaplain's house, and tracked to Beeland Street, and lost the scent outside of 19700 Beeland, Davontae Sanford's home. Gunshot residue testing. At the end of the dog track, Davontae Sanford's home, as I said, at 19700 Beeland Street. In the house were the clothes that matched the description given by the surviving witness. The pants tested positive for gunshot residue, a test that was used at the time. Guardian's consent. The night of the murder, Davontae Sanford approached the police that were at the scene and asked what they were investigating. Based on the ensuing conversation that took place with Mr. Sanford, the police determined that they would like to speak to Mr. Sanford at the station. Sergeant Russell went to his house and spoke to a Miss Tamiko Sanford. Sergeant Russell did not have a standard Detroit Police Department consent form, so he wrote out a consent on a sheet of paper, and Mr. Sanford signed it. Miss Sanford, the guardian, signed it. Mr. Sanford was then taken to police headquarters, read his rights, even though he was not under arrest, spoke to the police, and was returned home. The detectives went back to Mr. Sanford's house later that day and again received consent from an adult to convey him back to the police station. And that is a copy of the form that was used at that time. He was read his rights. He indicated that he understood each of them, and there's the form. He gave a statement that was typed. The detective testified to intentionally making mistakes in the typing as a check to determine if Mr. Sanford then read the statement. He brought the typed statement into Mr. Sanford, and he read it and made corrections. Mr. Sanford made corrections and then initialed each correction. He confessed to participating in the murders in the statement. At the same time as being given the statement, a sketch was drawn of the crime scene, which included the location of the bodies where they were found in relation to the couches. Information was contained in his sketch that would only be known to someone who had viewed the crime scene. You can see the similarities between the Detroit Police Department crime sketch, which was not available to investigators at that time because the evidence technicians from the Detroit Police Department were still drawing it, so it didn't exist at the time. Back to the timeline. Mr. Sanford was examined by the Michigan Forensic Center. Another thing that has been out there, I don't want to call it a myth, was that Mr. Sanford was never examined by any medical professional. Simply untrue. He was examined by the Michigan Forensic Center, and later, based on their report, a court found that he was competent to waive his Miranda rights and competent to stand trial. He was competent to waive his Miranda rights, and he was competent to stand trial after being examined by medical professionals. He then went to trial, and on the second day of the trial, he pled guilty. Another thing that seemed to be glaringly absent from any accounting was that this was a guilty plea. A guilty plea is a plea under oath. He was not convicted by a jury or a judge. He was convicted by his own words in a guilty plea. The guilty plea was signed, again, like I said, on the second day of the trial. And of course, after he pled, the jury was, the trial was over. It was a judge trial, I believe. Is that right?
That's correct.
Yes. And it was signed on the second day, after the video of his confession was played by the court, for the court, and in court, and his sketch was admitted. The plea form was signed by the defendant, his lawyer, and initialed by the defendant's mother. It was also signed after the prosecutor met with the victims' four families, the families of the four victims, the deceased victims, in the jury room with the trial prosecutor. This wasn't a young man that made his decision to plead guilty in a vacuum. He was consistently offered a chance to speak with his family members and any other person that he wanted to speak to before he made the decision to plead guilty. This is part of the transcript. This talks about, I'm not going to read the whole thing, but it goes through and it says, anybody promise you anything for this plea? And also he's under oath. Oaths mean something in the law. We don't take pleas of guilty from people unless they are under oath before a court. So these are some of the standard questions that are asked of a judge when a defendant pleads guilty. And of course, let's just go back. And then we will talk about some other things he was asked specific to this case. Whether he was promised anything, whether he was threatened, whether he was coerced, whether he was pressured, whether this was his idea, whether this is what he wanted to do. And is he doing this freely and voluntarily? Did he understand? And of course, we had the medical reports that said that he was competent to understand and competent to waive his Miranda rights. And then the judge asked some questions that I think are very, very significant here. And just so the record is clear, I let you talk to your mother and other relatives who you designated to talk to here in court. Is that correct? Yes? And we've taken breaks every time it's been requested of me to accommodate your ability to talk to whoever you wanted to for as long as you wanted to. Is that right? Yes. Did you get adequate and reasonable time to talk to everybody that you wanted to talk to? Yes. And he goes into the plea. Talks about whether he went to the Runyon address on September 17th, 2007. He named with other individuals, yes. He had a gun, yes. What kind of gun? He calls it a Mini 14 that he says he had under oath. It's bigger than a handgun and smaller than a rifle, yes. Loaded with live bullets, yes. Real bullets from a real gun, yes. And you shot into the house with the others, yes. And you killed by shooting you and you or the others you were with, shooting into the house that killed, and he names the 4 people there. And those bullets were shot from you and other persons, which took their lives, is that right? And then went into the house, and you see it there. Then the tort reminds him he's under oath. He says that 3 other people were with him. He said they were cousins of his. He says, can you name them? He says, I don't know their real name, and he gives their street names, which are on the bottom there at line 19. These are the same 3 names that he used on a later phone call, which was recorded in the jail when he was talking with his stepfather on May the 28th, 2008, where he identifies who was there, who was and who was not involved in the Runyon shooting. Going back to the judge's recitation during the guilty plea, and there's information there. He says later, that after the judge asked him, do you know what kind of long gun it was? He says, yes, an AK. Later, the Detroit Police Department, the ATF, and independent examiners agree that an AK-47 type firearm was used on Runyon Street. Davontae Sanford's identification of the AK-47 was corroborated by the physical evidence at the scene. Firearms evidence also became a concern and was one of the causes of concern about his conviction. He confesses to using a Ruger M14, as I said. A Mini 14 typically fires a different type of ammunition, none of which was found at the shooting scene. And as I said before, the ATF, the Michigan State Police independent examiner, former Michigan State Police examiner, and Detroit Police Department labs did not agree as to whether all the ammunition was found from one firearm. Detroit Police Department said that all the casings came from one gun, and you can remember this is during the height of the whole firearms scandal that went on back in 2008. And so the judge, one of the things he did during the hearing I'm going to talk about later, is ordered everything retested. ATF said that more than one AK-47 was found, and the independent examiner called by the defense, said it could have been even more. Back to the timeline. After the trial and plea, Mr. Sanford was sentenced and post-conviction hearings began. The post-conviction hearings began in 2009, and during the two-plus years of hearings before Judge Sullivan, Vincent Smothers was called to testify twice. Both times, he refused to testify and refused to answer any questions under oath. I'm going to get into those hearings in a minute, but the investigating officers, including Deputy Chief James Tolbert and Sergeant Russell, testified about Mr. Sanford's statement that I've outlined for you before, and the defense also called witnesses during this 2-year-plus period of time. Again, Vincent Smothers was called to testify twice and refused to testify on 2 occasions. So what we had left at that point was the defendant's plea under oath, and Smothers, a man who had killed multiple people, an affidavit that was sparse, and I'll get into more detail about that later, and a man who refused to put any testimony about his supposed involvement under oath in court, and was given more than one opportunity to do so. This next part is particularly important, and actually some of this was referenced in some articles that we looked at just this morning about some more false things that were participated about this crime, about this procedure. The State Appellate Defender's Office, SATO, represented Mr. Sanford at the post-conviction hearings from 2009 to 2011. Despite what's been said continuously about ineffective assistance of counsel at the trial, and as a former judge, I'm well aware that to challenge a guilty plea where the claim is actual innocence, the defendant and the trial attorney must testify to explain why the defendant chose to plead guilty and admit his guilt under oath. This was never done by Sato. Even though they're talking in the paper today about ineffective assistance of counsel, they didn't challenge it. Sato, the State Court Appellate Defender's Office, did not call the trial attorney, the defense trial attorney, or the defendant when presented the opportunity to challenge the confession and the guilty plea before the judicial hearing in front of Judge Sullivan. These are witnesses that the prosecution cannot call. We can't call the defendant for him to explain why he's challenging this confession. We cannot call the trial defense attorney during this hearing. Only his lawyers, Sato, are able to do that. They chose not to pursue those claims, even though now they're saying something different. We can't call those witnesses. The failure to present this evidence made Judge Sullivan's job more difficult, as well as our job, because all the court had to rely on was Mr. Sanford's plea under oath confessing to these murders. Let me just talk for just a second here about some of the delays. And some of you may be wondering why it took so long between 2009. Again, I said continuous proceedings were going on during this period of time, between 2009 and 2011. And just want to talk about a couple of the delays. And most of what it was doing was related to the firearms evidence that was retested. On the 18th of March 2009, the court ordered retesting of the firearms evidence due to problems with the Detroit Police Crime Lab that I mentioned earlier. On the 21st of July 2009, one of my appellate prosecutors informed the court that the ATF, who we went to have it tested, had completed their examination of the firearms evidence, and the defense then asked for an appointment of David Balish, who was an independent investigator who used to be a firearms examiner with the Michigan State Police, to do an independent after the ATF reports came in. And on the 16th of March 2010, David Balish testified about his findings of the firearms evidence that I mentioned earlier. And on the 3rd of July 2010, an ATF firearms examiner, Walter Dandridge, testified about his findings during this whole 2-year period of time. So over a year of those delays were because, and this was important, the judge ordered, and it was important and appropriate, that this firearms evidence be retested. Let's talk about something that has basically taken over some media accounts. And again, the perception has been all along, remember, we couldn't respond to any of the stuff that was going on all these years. It's unethical, it's improper, and we weren't going to do it because we were in the midst of these hearings in a court tribunal, and we're not going to talk about the case. We're going to follow our ethical rules. Defense attorneys don't have to. They can say whatever they want to say, whenever they want to say it. Prosecutors cannot. And we are going to be ethical in this office. It's important. So the perception always has been, and we read some of these accounts, I don't read them, people read these accounts and tell me about them, and there's a perception out there that we had this signed, cogent confession from Princess Smothers, and this simply wasn't the case. This case for us was never about Princess Smothers. This case for us was about the competency of the evidence that we had in this case. Let me also mention the interviews and affidavits. Interviews that are done by other witnesses during investigations and affidavits that are submitted by anybody, in this case Mr. Smothers, they're not evidence. They're not evidence. We do not agree, as I mentioned earlier, just to set aside convictions or set aside guilty pleas based on affidavits. That are untested in court. That would be abundantly irresponsible. Affidavits are simply precursors, I shouldn't say simply, affidavits are precursors to the main event, which is testimony in court, something that undergoes judicial review. There was never any testimony from Vincent Smothers in court during these post-conviction proceedings, ever. Let me also set the record straight on one other thing, kind of the evolution of Mr. Smothers' various statements and affidavits. He made several statements about the Runyon Street murders during the past 8 years. He made his first statement in 2008, a few weeks after Mr. Sanford pleaded guilty and was sentenced. The first statement was vague and devoid of any real facts. In 2012, and this is after the 2009 to 2011 series of hearings which were conducted, the State Appellate Defender's Office was there each and every hearing. We were there and presenting the case to court before Judge Sullivan. In 2012, Judge Sullivan issued a very detailed, cogent opinion that laid out all of the inaccuracies and omissions in Mr. Smothers' statements up to that time. Again, there was nothing under oath, but he had dealt with them all. In 2015, Mr. Smothers signed in 2015, 3 years later, Mr. Smothers signed a 26-page affidavit. Remember, the first one was devoid of any facts, any real facts. In 2015, he signed a 26-page affidavit that now had details that were addressed, all the details, answers to all the details that were addressed by Judge Sullivan in his lengthy opinion that he issued years before. Something else that is interesting to us, Mr. Smothers has submitted yet another affidavit in another case, nothing to do with this case, that claims responsibility for yet another murder, but my office has been recently notified that he's recanting that affidavit. It also bears mentioning that a perjured alibi was presented by Mr. Sanford's attorney, Sato, during the hearings before Judge Sullivan. And I should mention, I think I mentioned before, that everybody knew it was perjured. We had proven before, well before, when we were in the process of preparing for trial, and the defense had this information, that this alibi was indeed false. All made up, all a lie. But this was the alibi that was presented. An alibi, of course, means this was testimony from Bill Rice, William Rice, who used to be the head of Detroit Police Department homicide at one time in the past. And this alibi was, of course, presented to try to convince Judge Sullivan that Davontae Sanford wasn't even there, he was someplace else. It was a complete and utter fabrication. It was proved by phone records and other evidence. It's important to note that William Rice was in a personal relationship with Davontae Sanford's relative, and that he testified that Davontae was at a house with Mr. Rice. Cell phone records showed that his testimony was completely false, and later, in 2014, after we charged William Rice with perjury, which he's now in prison for now, we charged him in 2014 with perjury, where he pled guilty to perjury, perjuring himself during that whole alibi testimony. Prison for that and other crimes now that were later committed. Now, this testimony took place during a series of evidentiary hearings between 2009 and 2011 that I've talked about repeatedly. And this is the same evidentiary hearing where James Tobert and Sergeant Russell testified, but they, of course, they were on different dates during that 2-year period. Same hearing, where Judge Sullivan later issued in 2012 his lengthy, very detailed opinion about why the motion of Mr. Sanford should be denied. Back to the timeline. After the post-conviction testimony was concluded, the Circuit Court, Judge Sullivan, denied Mr. Sanford's motion to withdraw his guilty plea, and part of his opinion was based on the testimony of Deputy Chief Tobert. Later, the Court of Appeals overturned Judge Sullivan's decision, and later after that, the Michigan Supreme Court overturned the decision of the Court of Appeals and reinstated the Circuit Court Judge Sullivan's ruling. So this case has been looked at not just by prosecutors, although prosecutors seem to be the only ones responsible for all this that took place, but Sato and what they could have done at a much earlier date than now during the hearings, and they chose not to do for whatever reason. And 3 courts have passed on this case, including this state's highest court, which affirmed the decision of Judge Sullivan. So this was not the Wayne County Prosecutor's Office somehow running rogue and trying to do something illegal to Mr. Sanford. We went to court. We were in court for over 2 years after we received this information. This was completely litigated, passed on by a Circuit Court judge, the Court of Appeals, and the Supreme Court of this state. In April of 2015, Mr. Sanford filed a new motion for release from judgment. And as I stated at the beginning, I was the one who personally requested that MSP undertake this investigation. MSP, I should add, was the police agency that investigated and gave us the result of their investigation that led to us charging William Rice for perjury. And we went back to them, and I asked them to undertake a new investigation based on the motion for relief from judgment that had been filed in April of 2015. Again, we did that. Haven't seen that reported anywhere. The Michigan State Police unearthed new information not available to us at the time this case was charged. It wasn't available to us at the time of the trial and subsequent plea on the second day of trial. And it wasn't available to us at the time of the prior post-conviction litigation that I've been talking about that took place for that over 2-year period. This new information is what leads us here today, or led us to do what we did a few days ago. It has undermined Mr. Sanford's confession and plea, and as a result, we agreed to vacate his conviction and dismiss the case. 20 days ago. 20 days ago. Not 9 years ago. 20 days ago. I want to just take you through a little timeline. This is one that's guilty plea. Go back, or go forward, I'm sorry. Yes. So here is kind of a synopsis of what we've talked about already. The drawing of the crime scene was what we felt to be a pivotal piece of evidence, and was testified to that it was done completely in Mr. Sanford's own hand. But and aside from that, we had the dog track evidence that I've described. We had the firearms evidence that I described. We had the confession to the police that I have described. We had the gunshot residue evidence. We had the perjured alibi that I've talked about. We had the voice ID by the surviving victim, the only adult that was still left alive after this happened. And we had the trial plea. This all was the drawing of the crime scene that was done by, what we were told, by Mr. Sanford, was corroborated by all of that. The dog track, the firearms, the confession, the gunshot residue, the perjured alibi, voice ID by surviving victim, and the plea at trial. Again, we believe that this sketch was a key piece of evidence because of the corroboration I just talked about. It demonstrates knowledge of a crime scene and the aftermath of the crime. It's corroborated by, like I said, by all of the evidence that I talked about. We view the crime sketch that the evidence was that he had done at the time, to be important because of its origins. On the 13th of July, 2010, Deputy Chief Tolbert, as I indicated before, testified that Mr. Sanford drew the sketch from a blank piece of paper and then signed it. Sergeant Michael Russell stated that Mr. Sanford drew the sketch without being shown pictures of that. Mr. Sanford being able to draw the sketch would demonstrate that all of the information came directly from his recollection or from his participation in the crime. The Michigan State Police, during the investigation that resulted as a result of my asking them to follow up, based on the new motion that had been filed in 2015, they conducted a follow-up interview with Deputy Chief Tolbert during their investigation and submitted this interview with their warrant requests. I want to play for you now a key part of the interview that was done with James Tolbert.
So who drew the house here?
I think I drew the house.
Okay, you drew the house.
This is the house where we're lying.
Okay, so you drew the house and you said, hey, show me where the bodies
You were in there, this was the house, where the bodies.
Okay, and so then he just draws the bodies.
Right.
Okay.
So that's just a portion of the tape. And as you heard during this interview, Deputy Chief Tolbert, at the time of the Detroit Police Department, he responded to questions that undermined his prior testimony under oath, that Mr. Sanford created the sketch from a blank piece of paper. This interview with Deputy Chief Tolbert occurred in September of 2015. As you heard that we received the information on May the 20th of 2016. During that period of time, the Michigan State Police was being thorough, as they should. They continued their investigation until they delivered the warrant request to us in May of this year. Just want to make a little aside here. We are, as an office, and me personally, criticized all the time that our investigations take too long, and we should be doing quicker, and we should get the information out quicker. And this is just a shining example of why investigations take as long as they take, because we want to try to get to the truth, after all, is what we're trying to do in every case. In charging and prosecuting a case, my office relied on the investigations of the Detroit Police Department and the evidence gleaned therefrom. Every day, our appellate division receives motions and letters from defendants and prisoners who pleaded guilty and now regret that decision. Statements under oath to the court matter and must be held in the highest regard, which is why justice is not served by overturning every conviction by plea when a motion is simply received without investigation or without court scrutiny. But when the evidence undermining a conviction is discovered and a full investigation, in this case that was done by MSP, is completed, we act, and we acted. On receipt of the Michigan State Police report regarding the Runyon Street murders, I directed that the evidence of Talbert's statement be shared with Mr. Sanford's defense attorneys. My office attempted to stipulate with the defense after receiving this and reviewing their investigation to dismiss the conviction against Mr. Sanford, and were ordered to file a motion by the court, which was filed a few days ago. The warrant submitted on the Runyon Street homicides will be returned to the Michigan State Police for further investigation, as well as the warrant that was submitted by MSP for James Tolbert, which is currently still under review. Again, for us, this case was always about the integrity of the case, the evidence that we had that I've laid out for you, and it was never about anything else other than what the evidence was that we can prove beyond a reasonable doubt and whether it was sustainable. For us, the result of the investigation of Michigan State Police showed us that our building blocks of this investigation were now in question. And since they are now in question, we moved to take the actions that we've taken in the last few days. I'm happy to answer any questions for you, but I do have another announcement after that for a short while. Okay, I'm sorry. The warrant was submitted for the Runyon Street homicides will be returned to the Michigan State Police. I've just been reminded that we are still reviewing the other warrant. It's not been returned and will not be returned to the Michigan State Police until we complete our review. But I'm not ready to pass on that that aspect of it at this time.
Prosecutor, I know you laid all of that out. At the end of the day, this is a young man, obviously, who has lost almost 9 years of his life. Who and what failed him? The system as a whole?
Well, I have gone through the recitation of facts for a reason, and we follow the facts and evidence. We don't make decisions, any decisions on any case. I don't care if it's a car theft case, unless it's based and backed up by competent evidence. And so in this case, again, we asked for the investigation. It was done, and once we received the result of the investigation, we acted.
Would you have done anything differently?
As far as what?
Your part in terms of the investigation itself.
In terms of the investigation by Michigan State Police?
No, in terms of your reviewing of the case and making the decisions that you made along the way.
No, this case was charged based on the evidence that we had at the time that I laid out, and I laid it out for a reason. There was a guilty plea after 2 days of trial. There was 2 years of judicial review where we called witnesses, they called witnesses. They could have presented any time at that time that they could have. They didn't challenge the two things that they didn't pursue to its fullest the two things that I talked about, the guilty plea and the statement. That wasn't done. It could have been done. You should ask them about that. I don't know why. And then we then relied on, again, after a 2-year hearing with multiple dates and multiple witnesses before a court. He issued an opinion, like I said. It went to the Court of Appeals and to the Supreme Court. So we fulfilled our duties. We relied on the competent evidence. And then we received evidence, like I said, we received a report or investigation based on the Michigan State Police investigation, and it didn't comport. And we did not think we can continue, and we were not going to take this back to trial or do anything like that. We wanted to dismiss based on the evidence that was reviewed.
Why not ask the Michigan State Police 2, 3, 4 years ago to do what you asked them to do a year ago?
We were in hearings, and we wanted to hear from. We were certainly interested in hearing from Mr. Smothers about whether he was in fact responsible. There was never any evidence on the record from that person that he was responsible for anything. Affidavits are not evidence, but we tried to act on that. We wanted to hear from him. We brought him to court. We can't force him to testify, and we can't call him as a witness.
Ma'am, all the information that you laid out today was laid out in the 6500 motion and in your 2011 recitation of facts, other than the latest stuff about the MSP investigation. Now, on April 20th at a press conference in this room when you announced charges against William Melendez, we asked you also about, how you're justifying keeping him in prison when a lot of people said there was overwhelming evidence in the 6500 which had been
Okay,
filed.
I'm not following your question at all.
There was okay, bear with me, please, thank you. We asked you, someone in the media, it's actually on MLive's, the video of it's on MLive's website. We asked you, the 6500 motion had been filed.
You're talking about the one in April 2015?
Yes, April 2015. A few days after that, you announced charges against Melendez, and then we asked you as a writer about the 6500 motion. And what many people were saying was overwhelming evidence of the fact that Davontae wasn't guilty. And at the time, your answer was, there's a lot of evidence that you guys in the media don't know about. Your exact quote, I believe, was, you only believe what you read in the newspaper, but we're very familiar with this case.
Right. Now,
all the evidence had been laid out in the 6500 and your 2011 recitation of facts. So what is this hidden evidence that you said you had?
I don't think I used the word hidden evidence.
No, you didn't use that, man. You said there was evidence
there was
that
evidence
we weren't aware of.
There was evidence that wasn't reported.
Which was what? In the 6500 and your
in
what wasn't reported?
The 2 years of hearings that were had, there was a number of things that were not reported
But
that I laid out today.
in the 6500.
All of it was not in the 6500 motion.
Oh, really? So what like what? What was
there
it?
was more than 2 years of hearings that took place.
None of that was on the public record?
It was all on the public record, never reported though.
So that's what I'm saying, that you're saying there was information we didn't have. We did have it. We had access.
Oh, I guess, and chose to ignore it, I guess.
Well, no, I've reported a lot of this stuff.
Right.
But if let me ask a follow-up question. Now, you said that affidavits are not allowed. Are confessions allowed?
No, I did not say evidence.
No,
I said affidavits are not evidence.
Yeah, evidence. But are confessions evidence?
Yes.
Would Vincent Smothers detail confessions?
Confessions that are presented in court.
Okay, but
and under oath by whoever took that confession or was involved in it, and passed on by a judge as to whether we can go forward. We have hearings all the time where evidence is presented about certain confessions, and the judge has to make a decision about whether that confession is going to be able to be used in trial. So again, a confession is evidence once it is passed on in court. A confession sitting in a police file is not something that's going to be used by any court.
Didn't you block trying subsequent efforts of Smothers to testify in court?
No, I did not block something. He was given 2 opportunities in court
to testify. The first time he decided not to.
And the second time.
And the second time the judge blocked it. I thought there was a third. But
we did not at any time block Mr. Smothers
from testifying. If I could ask another question.
And again, let me remind you, it's not something that we can do as prosecutors. It has to be something done by the defense. You'll have to ask them why.
My last question. You put a lot of weight on in your filings. I poured through all your filings on the fact that there was gunshot residue on his pants and that were found in the closet. Did you put any weight to the fact that right after the murders, he was tested on his hands for gunshot residue and his clothing for blood and none of that was found? So it seems like the weight of gunshot residue being found on pants, which gunshot residue isn't used by the FBI
not anymore.
In court. Yeah, because
not anymore. It was used.
They don't use
excuse me, wait a minute.
Yes,
I'm not going to sit here and allow you to put things that just are not treating questions.
FBI doesn't.
So they are not used by Michigan State Police currently.
Yes.
It's not used by the FBI currently. At the time, it was used. That was but one piece of evidence that we relied on. That is why I talked about all of the evidence.
Yes, ma'am. But
not
did you
just
put any weight to the fact that no gunshot residue was found on his hands or his clothes immediately after this bloodbath?
We use the evidence that we have. And I don't know if in the trial that we were going to present, I don't know whether that would come up, but it's typical that when we deal with gunshot residue concerns when we were dealing with, it's typical that we put in reasons why it was not found. There was a washing of the hands. It could be there was a wiping of the hands. So I don't know if that exact evidence was presented at the trial because we didn't finish the trial.
Can I ask you a question?
It's called negative evidence that we typically put in so a jury understands why they may or may not find things, including fingerprints and everything else.
Ms. Worthy, I just want to make sure I understand the Tolbert part of this. So the tipping point was him saying, I drew the house. Did he say anything further than that?
He said, can we go back to that, please? The tipping point was getting the investigation from Michigan State Police and finding out that he was now saying things that were completely different from what he said under oath. And it's also important to note that it was the judge during the hearings, during this period, two-year period of time, that actually was the one who asked questions of James Tolbert to specify with clarity as to what he was saying. And the judge was the one that asked the questions about the blank piece of paper. We can go back and show that again if we can find it. Oh, there it is? Okay. So, again, if you look at line, let's just start with line 9. It says, the court, may I ask a question? Mr. Pulio, who was a prosecutor at the time, sure, go ahead, judge. The court, was the sketch done entirely, and this is the testimony of James Tolbert, was the sketch done entirely in the defendant's hand? Mr. Tolbert, or Deputy Chief Tolbert at the time, yes, it was. The court, so you gave him what? You gave him a blank piece of paper? Deputy Chief Tolbert, that's correct. The court, and then he drew everything on it except for Sergeant Russell's signature was the answer of the witness. So that's what we relied on, and that's what the court relied on during the particular hearings that took place. I don't know, I guess again, the 10th, the 2010, July 13th. That was during the period of time from 2009 to 2011 when this hearing was done. So that's something that we relied on. And again, that's why I showed you the building blocks on that particular sketch that we relied on, all of the other evidence, including the statement and the guilty plea and the tracking evidence and the firearms evidence that had been retested and the gunshot residue evidence that we had at the time. And so those are the things, and there were building blocks as to why this sketch was so important, because if he did the sketch himself, completely himself, that shows a familiarity to the scene and that you were there, if you knew where the bodies were. So then later, during this investigation, when it's found that this is not where he says that he drew certain elements, and maybe a distinction without a difference for some, but for us it was critically important because we relied so heavily on it.
That's what I was going to get at. I mean, you think that it's not a little white lie, that calls into question the entire statement of
It calls into question the building blocks of our case, yes.
Can you elaborate on any other inconsistencies between what was recorded and sworn testimony?
Well, that was what we relied on mainly, again. That was important to us, and that's why I talked about it in such detail. That was important to us as a major piece of evidence, that sketch. And when that piece of evidence, the credibility of that piece of evidence and how it is undermined, then we have to look at our case to see if we can proceed, and we decided we didn't want to because we had relied on that. We had relied on it heavily. Judge Sullivan had relied on it heavily during this 2-year hearing that he had. He relied on it heavily during his opinion that he issued in 2012. And I would assume that other courts, the higher courts, also relied on it. But we can say that we relied on it in our, not only our charging decision, but our decision to go to trial and everything that we did since then.
Madam Prosecutor, did you talk to Deputy Chief Tolbert prior to his testimony about this key issue here?
I did not do this hearing.
But before this, as the evidence was being gathered by the Detroit Police Department?
You mean during the
initial investigation?
I do not know if the person who issued the warrant actually talked to Deputy Chief Tolbert. We typically, before we issue warrants, we talk to everybody we can. I cannot tell you with specificity whether he was specifically one that was talked to.
And now the warrant that's under review in your office now is for what exactly?
Perjury.
And why is that still being considered and not sent back to him?
Because, again, we don't do things that way. We don't just take the word of anything. We do an investigation. And there are other things.
I was wondering what the distinction is between the murder warrant and this warrant.
The murder warrant, was that for Bridget Smothers? Yeah. Okay. The murder warrant was for Smothers and 2 other individuals, and that's nowhere near ready to be considered at this time.
So the other one is further along. Is that what you're saying? The other one has been investigated thoroughly enough.
It's still under review.
So is the state
The Tolbert warrant is still under review.
Is the state police recommending that Smothers and Nemo Davis be charged?
They submitted a warrant to us, but we are the ones that make the decision about whether we can go forward or not.
So all 3 have not been, you're still deciding whether to bring charges against all 3?
We have returned that warrant for further work to be done.
Why not just put the sketch aside and put Mr. Sanford on trial again?
We don't feel, I mean, that's kind of a, you mean, why not just put it aside, throw it away from the evidence and still go forward?
Well,
Because it was a major building block of our case. If we, for example, if we had a confession that was, not this case, that was a major building block of a case, and we found out that that could not be used, then that, in some cases we can go forward, in some cases we can't. In this case, we decided not to go forward because it was a major building block of our case.
You mentioned that he had mentioned other people would come. You said in your timeline
Yes.
he identified, and that ended up to be not true, correct?
I can't comment on that right now.
No one else was charged besides Davontae Sanford.
I'm not going to comment on that right now. We're still looking at that.
You pointed out that he identified other people, but you didn't say that those folks were ruled out.
That's right, I didn't.
Ms. Worthy, is there you pointed out very thoroughly how there's a responsibility to only act on what happens in court. Now, what's Is there a similar responsibility for a prosecutor's office to examine its own procedures, to do its own audits on the way justice is exacted through the office?
I don't understand your
Is
question.
this something that you could have done on your own, go back through the case when people were raising
To go out and investigate it?
about years ago, or did you have to wait for it to go through court only?
We went through court for a
Right.
judicial determination, and then again, we asked for, after we got the new warrant, the new motion, we asked for the law enforcement to go out and investigate. So we're not investigators.
Right,
We
I'm
asked
just
for,
wondering if there's ever a position that you're in where you ask your own office to examine.
yeah, we have investigators here, and there are cases where we ask our own investigators to examine.
But you
We
didn't do it in this case?
we turned to the Michigan State Police because they had done a previous investigation related to this case, which was very thorough as their investigations are, and we turned to a very competent, highly respected by us organization to do the investigation.
Your office fought very firmly in the Smothers case to use his confessions against him.
You talking about his other cases?
Yes.
Okay.
To use the confessions that he gave in the other homicides, in the cases that he eventually pleaded guilty to. The allegation here is that he also confessed to the Runyon Street at the same time.
In an affidavit, yes. At the same time, it was later.
At the same time as the other 8 during the police
He
interview.
confessed to police, not
hold
just
on.
in the affidavit.
He was arrested.
Yeah.
He spilled his guts on 12 homicides.
Mm.
But of course, he was only charged with 8. He fought like heck to make sure those confessions came in.
Yes.
Judge Strong ruled in his favor and pleaded guilty. But people who hear about this, lawyers and non-lawyers alike, kind of scratch their heads. If he made these admissions about Runyon Street, yet they were set aside, but they were part of the other confessions.
And again,
Perhaps just as important as the other 8.
and again, we found that out, I think, shortly after the sentence, and we tried to deal with it during the hearing, as I indicated, but we could not then call him as a witness in this particular case.
But you believed him in the other 8, why not those 4?
Can I just jump in? Sorry. Why not tell the state police, hey, we got these 4 to Runyon on Runyon Street, reinvestigate this. No matter what Davontae Sanford wanted to do with a motion for relief. How about
Again,
this,
in
hey,
those-
guys,
in those
hey, guys,
ca-
get these 4, investigate these 4 on Runyon Street. We got this hitman who we're confident on these 8 other
And others,
confessions,
yes.
but Runyon was set aside.
Again, the statements in those cases, we, again, sustained judicial review, and they were corroborated by other evidence, and we went forward on those cases. So on this case, again, it wasn't until 2008 that we received evidence about him admitting, what day was it? 2009? Okay. In 2009, where we received that information.
He confessed in 2008, and then he also said where the murder weapon be found, and at Ernest Davis's cousin's house, and that ballistics matched up. Ballistics also matched up that an AK-47 used in the Runyon
And there
murder
was-
had been used in another Smothers
And that was
murder.
after
Yeah,
we
sure.
got the
but
information.
as
That
I was
invest-
saying, why
that invest-
couldn't you have at that point
you gonna let me
said?
s-
I'm sorry, ma'am, if I could finish my question with respect. So couldn't at that point, with the evidence that Smothers gave, and you said something earlier that Smothers gave inaccuracies during his confession. What were those?
No, I said
I'm sorry,
that
I thought I
during the
heard that.
affidavit that we received.
Okay, because
It wasn't
during
during
his
the-
confession, he told a lot of things, including like the shootout.
Which question do you want me to answer?
I'm sorry. Yeah, why? The question is, there was a lot of evidence in Smothers' confession which may have indicated, and a lot of people said indicated that it indicated his guilt. And your answer was always, well, it doesn't matter whether he said it doesn't exonerate Davontae.
That's
Couldn't
not
you
what I
have-
said.
You did in your filings, yes, ma'am. In your filings, one of the things that you said was
You're
the fact that
you're transposing the word statement and affidavit.
either way, you're saying the fact that Vincent Smothers, to use street term, copped to the murders
Mhm.
doesn't exonerate Davontae.
Right.
The question is after the fact, after you got all this evidence, that, the gun he used was found where he said it would be.
And we got the evidence by
Couldn't
doing,
you have,
we
after
got
the
the
fact-
evidence by doing an investigation.
Yes, ma'am.
And we later got that information. There was also extensive work done during this period of time.
There
You're
were a
tr-
lot
you're-
of appeals
You're
between-
trying to insinuate that nothing was done. There was also extensive work done during this time to see if there was any connection between Davontae Sanford and Mr. Smothers as well.
Right.
Investigations don't take place like they take place on TV. They take time, and they take attention. And it's not like we can just take something and then run to court or do something the next day.
Understood.
It
And
takes time.
8 years has transpired between that and you guys.
8 years
deciding-
didn't transpire.
8 years transpired between Vincent Smothers making that confession with all these details that were accurate. That again, the shootout with the pastor
first-
and talking to the lady under the bed. That's all stuff that only someone who was there. So a lot of time passed between then and your decision recently in the last few days to drop the charges.
Well,
so yeah, they do take a long time. I understand. What I'm saying is, couldn't at some point, with all that evidence you did have, which was also brought up during all these appeals, what's different recently to where you said, oh, we need to look at this case, I'm going to ask MSP, to reiterate Ed's question, couldn't you have done that at some point with all this, what appeared to be, and what a lot of people were saying, overwhelming evidence?
No.
Why not?
No. That's why we laid out the timeline.
Okay.
He pled guilty. There was a sentence. The information was received. There was a 2-year hearing during which during this period of time there was investigation that was being done. When we heard certain allegations about certain things, they were fully investigated. So then after the ruling by Judge Sullivan in 2012, that was done. It went up through the courts. And then we received the new motion, and that's when we asked for the new motion to be investigated.
At this point, based on the MSP report and everything else you know, do you believe that Davontae Sanford had any role in this?
How I feel about a case is not important.
Well, it is. It is
how,
important.
no.
It is important.
No, it's not important about how I personally feel about a case. It's not that we're not going to go forward on.
Well, professionally or personally,
I'm not going to comment. I am not going to comment or answer that question. It is still being investigated, not with Mr. Sanford, but it's still being investigated. It's inappropriate for me to comment about what my personal feelings are about his involvement in this case. I'm just not going to do it. We issue cases all the time where we may feel a person is guilty of sin, but if we don't have the evidence to prove it, we don't go forward.
So is it inaccurate for us to say he's been exonerated?
I'm not going to answer that question. I'm not going to answer that question.
But you give that opinion on the front end when you charge people, and before, I mean, you've already kind
It's not based on personal opinion. It's based on what the facts and evidence were, and that's why this case was charged in the first place, because we felt that we could prove it in court beyond a reasonable doubt. We went to trial. There was a guilty plea. And again, I do not make charging decisions based on my personal feeling about what I think happened and occurred.
Well, did the facts and the evidence show that he had a role in this? It's usually the words facts and evidence.
Yeah, I'm not going to answer that. This case is still under investigation. I'm not going to give you my personal opinions on what I think.
But it's a little unfair to him to have this hanging out over him after he's been let out of prison. Yes, he doesn't have charges anymore, but unless you come out and say, we don't think he did this, it's always going to hang out there.
There is an investigation of the Runyon Street homicide that's still outstanding. I am not going to comment on what my personal opinion is going forward.
Well, again, we're just talking about evidence. Isn't the fact that you dropped the case indicate that you don't have evidence?
I'm off the case.
That you dropped the case against Sanford?
Is that what you heard during all this, that I dropped it because we don't have evidence?
No, ma'am.
Okay.
I'm asking you, doesn't the very fact that you dropped the case indicate that you don't have the evidence that he was involved?
I'm going to answer the question again, and I'm not going to comment no matter how many different times you ask the questions.
How come, no? I mean, why wouldn't you comment?
It isn't
on your public
appropriate. There is
official,
still
man? This is a charging.
There is still an investigation going on the Runyon Street homicides at this point. I don't ever comment during investigations. I'm not going to do it. I'm not going to start now.
Just a little more broadly on it was asked kind of, but the report by state police, did it reveal any other discrepancies in what the evidence put forth by Detroit police in this? I mean, that would kind of indicate maybe some broader problems at the time in the homicide unit?
Again, this case is still under investigation. The opinions could be varied. They could be varied. And we relied on specifically, and most importantly, on the sketch and the varying information that was available at that time. Testimony that was given under oath, it was different from testimony given under oath that was different from evidence that was gathered by the Michigan State Police.
But there was nothing else that looked like it was intentionally put forth or changed?
That would cause me to comment on that warrant that we're still looking at.
How come you can comment on the sketch and all that, being that this is an open investigation?
Because that's the reason why we dismissed against Mr. Sanford.
So that evidence that sketch seems to be like you held that in, and other than the other stuff, that was secondary?
No,
or?
that sketch was corroborated by all of the other evidence that I talked about. Again, it was corroborated by the gunshot residue. That was one piece of it. And not even the most important piece. It was corroborated by the dog tracking evidence. It was corroborated by a statement. It was corroborated by the guilty plea, and which was never shown to be anything other than accurate. And it was corroborated by the firearms evidence. It's not just. It is not just the sketch.
And the dog tracking, wasn't that? that was down the street. It wasn't outside his house. It was down the street. It was on his street.
It ended at his house.
At his house?
Yes.
The state police concluded that someone
Let's
got in a
go
car.
back to that.
Did it go up to his house?
Let's go back to that.
I can find that if you want. The police, the K-9 unit said that they indicated that someone might have gotten in a car because it disappeared on the sidewalk. It didn't go up to his house, correct? Up the stairs or any to his house.
It did not go into his house.
Okay,
That's correct.
so it seemed like it was maybe someone got in a car, so maybe he ran back to his house, got
See,
in
the
a
thing is,
car and
you
got
can
away?
engage in maybes and seems and all of that and possibilities. I cannot do that and will not do that.
You brought up the fact that it went to his house.
It did go to his house.
Near his house,
that's a
outside
piece.
his house, and then it disappears. It didn't go up into his house. I'm just making it
It also
clear.
didn't go into any other house along the way
Right,
either.
yeah, and the investigators at the time concluded that they must have gotten in a car and driven away.
Again, I am not going to base anything I say based on what someone may have concluded at this point.
Well, that's what the police,
Again.
in your investigation that you cited, that's what the police concluded. That's what you based this on, isn't it?
Again, this is the way that it was tracked to, I think it's 19700 Beeland, to
And
the
then
house.
the police concluded that someone got in. So he ran all that way, what we're thinking is he must have run all the way to his house and then got in a
You
car
can
and
think,
driven.
people can think
Yeah.
what they like, but again, I have to base what we do on the evidence. My answer's not going to change. That's what I'm going to do.
Thank you.
I'm not going
I
to
don't-
speculate about anything else. You can speculate, but I'm not going to speculate.
Based on all the circumstances, you make it sound kind of like this was unavoidable, and I guess there's no way to look at different things that you might recommend to try to avoid this in the future. I mean, is there anything that could be done in this case? I mean, stop relying on dog scent tracking. I mean, is there anything that could avoid that you
Dog
could
scent tracking hasn't been
recommend
found to be unreliable, and I didn't just rely just on that. Again, there were a number of things that we considered. It wasn't just one fact or another. All of the facts that I listed for you were the ones that we relied on.
But is there anything to be learned?
And we were looking from, go ahead, I'm sorry.
Is there anything to be learned from this more broadly, from this whole case?
I think there's always things to be learned from any situation. And perhaps if, I hope maybe this could have done faster, in fact, if we had more people. But I'm not going to rely on that. I'm going to rely on what we had, and that's what we did. Again, we relied on a court finding, a court hearing that took over 2 years with various delays for various reasons, one being the firearms testing. Everything that we wanted to present at that time was presented. It also is important to note, very important to note, go back to the SATO slide, please. That they did not call witnesses that they could have called. And perhaps, and I will speculate on this, perhaps if either Davontae Sanford had testified or the trial lawyer has testified, the judge may have made a different finding, a different ruling. We don't know because it never happened. And we cannot by law call those people. So that's one possibility. And so I don't know why he wasn't called. You can ask them during his press conference today. I don't know why he wasn't called. I don't know why the guilty plea wasn't fully challenged by the defense.
David Moran, who's had a lot of success in this court and courts throughout the state on these types of motions, said yesterday that sometimes it's hard for police and prosecutors to believe that somebody was wrongly convicted, mistakes were made. He says it's just human nature.
David Moran says a lot of things, but it's certainly not hard for me to understand that mistakes are made and that humans are frail, have human frailties. We deal with 20,000 cases a year. We're presented with warrants all the time, and we don't issue all of those warrants. For example, I'll just give you one stat. In domestic violence, we get anywhere from 7,000 to 8,000 a year. We issue 3,600. That means there are over 44 warrants that we don't issue. Because we look at those cases, we determine there's one issue or another why we can't charge. We don't charge every homicide case that's brought to this office. We don't charge every rape case that's brought to this office. We look at it, we examine it, we determine if, in fact, we can make a recommendation to charge, and if there's going to be a charge, what it will be. We don't charge, and we're criticized all the time by police agencies. We don't charge a lot of cases. We don't just go by the word of a police agency. We don't take a warrant and just sign it if it comes in. It says it's a victim, and we don't just sign it because the police said it happened. It's no disrespect to the police, but if we have to be factual and we have to be complete, and so we take our time with a lot of these investigations. Some investigations or some cases are easier. The simple gun cases or simple drug cases maybe they're easier. Maybe we can make those decisions in a day or a half a day.
Well, he's talking about a willingness to say maybe conviction was wrong.
This office has done that in the past. When we've done that in the past. Let me just put it that we have done in the past, and I have said things differently in this case in the past. There have also been cases where we have contacted the various innocence projects. when we looked at a case and we said something's wrong, and we called the Innocence Project, including Mr. Moran's office and other offices, where we called them and we wanted to have one of their lawyers look at a case because we felt something was wrong, because we wanted investigation done. I don't have any examples right now, but there was one case, there's a couple of rape cases that were like that.
Your case was strongly, you said in filings and today that two of the major building blocks of your case was his confession to police and his guilty plea. As prosecutor, I'm assuming you're aware that in 30% of the cases where DNA exonerates somebody, a false confession, they didn't do it, the DNA proves it, but they did confess to police and they did plead guilty. Are you aware of that?
I am not going to accept those facts as true. I don't know those to be true. If you're asking me if there's certain false confession cases and all of that, of course there are. But
was the fact that he was 14 and interviewed without a lawyer or any of that, was that concerning to you as you went through this case at all?
There was nothing that was done improperly as that was concerned. And again, there seemed to be this this myth out there that somehow he wasn't examined by a licensed professional, and he was.
No, I didn't say that.
Okay.
He was. I know
he was.
But I mean, just the fact that he was talked to twice. His first confession, he gave all the wrong info, including what clothing he was wearing. He wore a brown shirt. And then later, after what many people say he was coached, I mean, any of that concern, he then provided, and in fact, I have the video here of his confession in which basically the detective is reading him facts, and that's kind of contrasted with Vincent Smothers' video in which he freely talks about intimate details of the case. So none of that was concerning to you during all the appeals process, anything like that? The fact that a 14-year-old kid was talked to by police and without a parent or lawyer present, any of that concerning to you?
First of all, there was consent for him to be talked to.
I know there was a form signed,
so
sure, but
you seem to be indicating that this
well, the consent from the mom was that he was not it said that he's questioning. He wasn't indicated as
okay, you've asked me, like, I don't know which question you want me to answer.
Well, was it concerning to you, all the discrepancies in his quote-unquote confession?
Everything in any case concerns me. And that's why, like I said before, we don't issue every case that comes through here.
But it wasn't
there
are
many cases that we don't issue. We did not drop the charges until a major piece of our case that we had relied on and that the court had relied on and courts had relied on was found to be problematic.
So that
and so
indiscrepancy is more important than the other.
As a result of that, we made a motion to dismiss our case.
Thank you.
Do you,
not based on any speculation, innuendo, but evidence.
There's no speculation.
Okay.
now that you have all the evidence you needed to back off on his conviction, do you think there's anybody that owes Davontae Sanford an apology?
I think I better stay away from that. I'm not going to give you my personal opinion on that.
Vincent Smothers said in his affidavit last year that he initially received a plea offer to 50 to 100 years, but as long as he didn't testify to his confession of the Runyon Street murders. Is that accurate?
I don't know that to be accurate, no. Where did you get that from?
It's in his affidavit.
No, that's not true. We would never do that.
Why did you cut a deal with him when he was freely admitting to all these cases?
He pled guilty. How many cases? I don't know how many cases he pled guilty to.
The 8, you ignored the 4 and decided not to charge against those, but you believed him on the other 8.
You know, I would really appreciate, and maybe it's not your way, but don't tell me what I'm not concerned and what I am concerned about.
Well, you didn't charge him,
okay.
So I mean, I'm assuming you didn't believe him on those 4.
I'm not
speculating.
I'm not
there.
sure
you
how many.
Vincent Smothers with the 4 murders he confessed to, but you charged him with the other 8 that he did confess to. My apologies. I'm not speculating. I'm assuming since you didn't charge him, you ignored those, right?
It is not exact. It's not. I don't know how many murders you want someone to plead guilty to. If you have, well, I think it was 4. I don't know how many he pled guilty to, but there's a sentence you're going to get, and that's life in prison without the possibility of parole, or maybe it was numbers that we gave him. But 50 to 100? Okay. And how old was he? He's late 20s. So he would be over 70 when he got out?
Sure. I mean, I'm just wondering why even cut the deal? You had him. He already confessed to it. Didn't sound like he was even fighting. I mean,
had him on what case?
He confessed. I did these murders.
Yeah.
Here's all the evidence. Here's where the gun is, et cetera, et cetera. So why even cut a deal with him? That was a surprise to a lot of people.
Which case are you talking about?
Vincent Smothers murder cases. The other 8, not the 4 that you decided not to charge, but the other 8. You cut a deal with him. Now you're saying that deal wasn't contingent on his silence on those other 4.
No, we don't.
That's an absolute falsehood.
That's an absolute falsehood.
Saying that's fine.
Yes.
But then why cut a deal with him at all when he's copping to all these murders? Couldn't you just take that? It wouldn't be an easy win.
Again, there were, I think it was 4 murders that he pled guilty to. 50 to 100 years. We knew he was never going to get out. Typically what happens, and I don't know if this happened in this case, but typically what happens, we will discuss some of the issues with other family members that we don't charge and let them know what we're doing. I don't know if that happened in this case, but typically we don't need to get, if someone's going to prison for 50 or 100 years and they're going to be over 70 when they get out, there really isn't any reason to go to trial when they're going to admit that responsibility with those kind of numbers.
And can I ask you one more time, why did you believe him on those 8, but you didn't believe him on the run-ins? You believed him enough to charge him for those 8, but you decided not to. Is there any reason why?
Again, these are in the affidavits that were given by Mr. Smothers, and I went
No, I'm
through
talking about the confession, ma'am. The confession
Okay.
you gave the police.
Let's go back to that slide, please. There was follow-up investigation done, and I laid that out already. I'll lay it out again. That's where the firearms evidence that was found that linked some of the guns used in other cases to this particular, that's how we found out. We didn't find out in a vacuum. We found out because we looked at the confession, we looked at it, and then we made certain investigations after that. That's also when we did, again, I stated this before, that's when we made many efforts to determine if there was a link between Vincent Smothers and Davontae Sanford. I resent a little bit that you seem to be in saying that we did nothing
Well, I apologize.
after looking
No.
at those.
Subsequent
When
investigations
that-
revealed that the
that-
firearm used had been used in another
That's right.
Smothers murder,
Subse-
and that Smothers said the .45 pistol was found in Ernest Davis's cousin's house. So that's the
Subsequent
events.
yes.
Yeah, that's what you're talking
So
about.
we
So
didn't,
with that new
we
information,
didn't just,
yes, ma'am.
we
But
didn't
with that
just
new
ignore
information,
it.
why didn't you then charge Vincent
Again.
Smothers with those 4?
all right, let me know when you're finished talking, and I'll be
I'm
happy to
sorry,
answer
my
the question.
apologies. Sure,
Okay, do you want me to answer the question now?
please.
All right. As I said before, we did follow up on information that was in those confessions. That's how we found out about that information. We didn't just set it aside. That's how we found out about the information that I'm talking about now. And then we followed it from there.
And that wasn't strong enough to charge him with those 4,
No, it wasn't.
despite the fact that he showed you where the gun was.
No, it wasn't.
And that his gun was used in that. His AK-47 that was used to kill the other dope dealer was used in the Runyon, but that wasn't strong enough to charge him with those 4.
No.
Okay.
And we always believed that we always knew that there was more than one shooter as well. If you
Which
see,
is what he confessed to, sure.
There's
That
more than
Ernest
one
Davis
shooter.
was the shooter as well, sure.
anything else?
One last thing, the gun that Davontae Sanford said he had used, the Mini-14, there was no evidence.
Yes,
Also,
I said
and
that.
he said he threw it over the
There was no
fence.
evidence linking that gun to any of the fired evidence at the scene.
There was no gun ever found in that area. He said he threw
I
it
said
over.
that.
Yeah, okay.
Yes.
But that was still, even with the lack of firearm evidence on Davontae's side,
We knew that there were,
and the strong firearm evidence on Smothers' side, you're still saying that there wasn't enough to
Again,
charge him with those 4.
again, this case was never about Smothers to us. This case was about whether the evidence that we had against Mr. Sanford were enough to sustain a conviction beyond a reasonable doubt. That's why everything was done for the last 9 years that has been done. This is not a case where, as I said before, and I'm going to end on this, this is not a case where these allegations were made, they weren't followed up. I don't know what kind of, maybe it wasn't done to your satisfaction, but we did everything that we could do to follow up from those confessions. And then we had, again, the 2 years plus long hearing where the defense, as well as the prosecution, had an opportunity to call witnesses. They chose not to. They chose not to deal with, for whatever reason, that's something you have to ask them, on issues that get to the heart of some of the questions that you're talking about. So perhaps if there had been testimony by Mr. Sanford and been testimony by the trial attorney, perhaps Judge Sullivan wouldn't have made the decision that he made. But we didn't have that because they did not testify. And Mr. Smothers refused to testify on 2 occasions. And so we have to go by what we have under competent evidence in court and nothing else. What we had was a under oath statement or under oath plea by Mr. Sanford, and we had, again, the items that I pointed out about Mr. Smothers. We had nothing on the record about his involvement because he wasn't called by the defense.
Had you charged
Now,
him with them?
anybody else have a question?
Prosecutor Worthy, I'm sorry,
testimony.
I've been gracious with your time here. Just so I'm clear, looking back at everything, would your office have done anything differently?
You know, I don't know what we could have done differently as this case went through time. I really don't. I can't be a Monday morning quarterback. I can't go back and, but when we looked at everything very carefully they laid out to you, we had a good reason to charge. We thought that when we charged, this case would be proved beyond a reasonable doubt. Again, it seems to be glossed over that we started a trial and there was a guilty plea. He admitted responsibility for what he did. And then after that, there was, like I said, the 2 years long hearing where his guilty plea wasn't challenged. And it wasn't followed through. His ability to understand and waive his rights, again, it wasn't followed through. Those are two big issues right there that could have put an end to if, in fact, the judge believed that he either could not understand his rights for whatever reason, or he did not competently give that guilty plea. There's no way to challenge that unless he is placed under oath and testifies about the facts and circumstances surrounding the plea. There's no other way that can be done, and that's not something that we could do. We would have welcomed that. We expected that, but it did not happen. Usually when there's an actual claim of innocence to the taking of a guilty plea, we expect that certain things are going to happen. It didn't happen in this case. It could have ended right there if there had been testimony by Mr. Sanford or the defense attorney to explain his reasoning for pleading guilty at that time. So we're left with a plea under oath and the findings of 3 courts in the state. Anything else?
Just to be clear, through the whole proceeding, they never challenged the plea?
They didn't
or
follow
waiver of
through.
rights?
I think it's more accurate to say they didn't follow through.
They didn't follow through.
They didn't follow through on those challenges.
By having Smothers testify or have, not Smothers.
Well, they wanted him to testify. We wanted him to testify, but he refused. So we can't make him.
Sanford testify and they
Yes.
never had the defense.
We would, like I said, we would have welcomed Mr. Sanford testifying for purposes of this hearing. We would have welcomed the defense attorney testifying. We cannot call them. That could have put an end to this back in 2009. Should the judge find that he believed them and he wasn't competent or whatever. Yeah. So I'll be back in a minute. I have one more case to announce.
Everything she said
I thought it would be
was
a lot
laid
more
out
than
in
just he drew the outline of a house. Like,
Yeah,
I
so
thought it was
that
bigger
was,
than
and I asked her, and I guess she's saying that outline of the house evidence was crucial evidence. That turned out to be not true. All the other evidence turned out to be not true. Apparently, that's not crucial.
It looks a little bit like he drew out just something for his kid next to this way.
They were interested in.
They may have to just pull a right or something.
Yeah, right.
Someone will actually have to write something.
Hey, George.
Will we get that full slideshow?
You will.
Thank you. With the dates and the timeline, everything on there?
Everything that was on there you're going to get.
Awesome. Thank you.
I have not. Yeah.
We'll write it here. Do you understand that email?
Not yet. The arraignment's at 2:30 today for the Mitchell homicide case.
So this is the last we're going to talk about?
It is.
Is-
Well, 30 over there, but it might be video.
Over there.
Yeah,
Yeah.
usually the arraignments are over there because they're before a magistrate, and they don't travel over here, so. too.
You know, before we get started, can you have them give their names
Yeah,
and
I will.
spell them?
I will. You can sit on this side for this.
Okay. You want me to sit over there?
No, you can
Where's
sit
Mark?
here.
Mark?
We can take our time. Okay.
This is gonna close.
Oh, yeah.
They want to be here for this particular
Okay, well, have them come in.
Bob, you need to.
We just need to wait for the people involved in this to come. We'll be starting in a minute.
Ready? I think everybody's here.
Wait, one more.
One more.
JD?
Channel 2 is here.
Oh, are they coming back?
They're coming in.
Well, but, Kim, don't go through there.
I'll have this one? Okay. Bring them to the back. Thank you.
If everybody's in, when you're done, please close the door. Thanks.
You ready? Okay, we're here now to talk about a case involving young Davontae Mitchell. And before I get into what I'm going to say about this, I want to start to my right and your left and have the prosecutors here introduce themselves. They've been working very diligently on this case for a long time. Go ahead, Bob.
Morning, Robert Stevens, Deputy Chief of Special Prosecutions.
Fatima Saringas, Director, Homicide Unit.
Brian Surma, Assistant Prosecuting Attorney.
Kelly Gleason, Lead Attorney, Homicide Unit.
And I'm Rob Miranda, Chief of Special Prosecutions.
Okay, all of you are aware that on June the 1st of 2016, that young Mr. Mitchell and a friend were in an alley in the rear of a store on the 15900 block of East Warren when they observed a man drop an amount of money at about $70. And they were on their bicycles, they picked up the money, and they rode away. You already know also that we have previously charged a Mr. Ernest Coleman with the charge of kidnapping. It's alleged that Mr. Walker, Miss Roberts, and Mr. Coleman kidnapped Davontae at gunpoint near the store and drove away with him in a car. It's further alleged that he beat the child. He beat Davontae Mitchell, that he was later choked to death while aided and abetted by two other defendants that we're going to talk about in a moment. On June 2nd, 2016, the lifeless body of Davontae was found in a field on the east side of Detroit. He was transported to the medical examiner's office where his death was ruled to be a homicide, and then the case was investigated by the Detroit Police Department, the Homicide Task Force, and the Violent Crimes Task Force. Today we are charging Gregory Walker, age 44, Lillian Roberts, age 43, and Ernest Coleman with additional charges in connection with the death of 13-year-old Davontae Mitchell. All the people involved are from the city of Detroit. On June the 2nd, Walker and Roberts were located in Toledo, Ohio, and were extradited back to Detroit this week. On Sunday, the 5th of June, Mr. Coleman was arraigned on the kidnapping charge, as you know, in the 34th District Court in Romulus and received a $1 million bond. Today, we are issuing the following charges. On Gregory Walker, we are charging him with one count each of first-degree premeditated murder, first-degree felony murder, unlawful imprisonment, kidnapping, torture, felon in possession of a firearm, and felony firearm. Lillian Roberts, we are charging her today with 1 count of felony firearm, 1 count of felony murder, 1 count of kidnapping, 1 count of torture, 1 count of unlawful imprisonment, and felony in possession of a firearm. Mr. Ernest Coleman, as in addition to his kidnapping charges that I talked about before, we are charging him today with 1 count each of felony murder in the first degree, torture, unlawful imprisonment, felony in possession of a firearm, and felony firearm. The defendants are being arraigned today?
2:30.
These defendants are going to be arraigned today at 2:30 in the 36th District Court. Yes?
Prosecutor Worthy, what do you have to say to the people? Because it seems like there were probably at least a couple, if not several or more people who could have intervened in this, could have called for help before Detroit police were notified or aware of everything that was happening because there were so many moving parts to it. What would you say to the people out there, if not for Davontae, but for other cases, that they just see something happening and they don't act when they could or should?
That there's value in being, and this case is much more complicated than it first seems, but there's value in being human. And part of being human means getting involved. I understand that some people are afraid to get involved for various and sundry reasons, but when you're talking about a 13-year-old child that allegedly many people saw in the act of his being kidnapped, etc., I don't know how you can frankly call yourself a person with feeling. This case, of course, has touched a nerve, and the alleged facts in this case, I think, will further unnerve people who simply want to see this be a safe city and want to see our children be safe. It's time that we as a general population, stop giving lip service for wanting our children to be safe, and that children are our safest resource, and everything that people say about children every day, including elected officials. But if you're not willing to put your money where your mouth is and help a child that is in obvious distress, or at the very least get involved at some level if you feel your life is in danger, then that should be done. Some of the alleged facts in this case, there's just no excuse for.
It's hard to believe that Davontae did not know any of the 4 people you have in custody right now.
Well, again, the particular facts beyond what I've said will come out in court. And as for something to be hard to believe, this whole thing is hard to believe. You're talking about 6 prosecutors who've been around a long time, probably a combined over 100 years of experience probably among us all. That's probably a low number. And this case shocked us all. And there's not a whole lot that shocks a seasoned prosecutor. So again, some things you just cannot explain. And we in the criminal justice system just to make sure that we hold the people responsible criminally that are responsible for this.
Prosecutor, is the part of the shock Davontae's situation on perhaps being on the street, if that's true, and no adults looking after him, if that's true?
Mr. Mitchell was a victim. I'm in no way going to blame the victim for any kind of behavior. The facts being what they were, there's no excuse. Even if this happened at 4 o'clock in the morning, there's no excuse for what happened to him and the way he was treated.
Roy Portis was also arrested.
I'm sorry?
Roy Portis was also taken into custody. What happened with him?
Again, we are making a charging decision on these 3 individuals, and the investigation is completed.
And not victimizing the victim, I mean others involved in his life or not involved in his life. Was he victimized by others before this crime by being kind of placed on the streets? Was anyone looking after him?
Again, my comments are only to the charges in this case. I'm not going to get into why he was there. What is irrelevant as to what happened to him, in my view.
Is anyone involved in his life under any type of investigation?
As far as we are concerned, as far as criminal charges are concerned, this investigation is completed and it's over. And we now move on to the next cycle.
Just the one weird aspect about this is the beginning. Like, did he steal the money, or did he just innocently pick it up off the ground, or what do you believe happened that sparked this?
The alleged facts are what we have alleged here, that the money was picked up that was dropped by one of these defendants.
But were they trying to get it back? Is that what led to the kidnapping? Did he know he took their money?
Again, I think any further facts, for various reasons, we're going to wait until come out in court.
Talk about Gregory Walker. He had violated his probation over a year ago. A warrant was issued. Warrant was also issued in April. for his arrest. Do you think, how many other people like this are slipping through the cracks? I mean, hundreds, thousands, where they have bench warrants, they should be locked up, could be locked up. He should have been serving time on his original stolen car case, but they're still out there just kind of freestyling.
I'll answer your question generally and not specifically to this case. It's not unusual in this jurisdiction for people to be picked up that have outstanding parole violations or probation violations. Not unusual. Obviously, true, if certain things happen and people are held responsible earlier, perhaps certain things don't happen, would not happen. But all I can say is it's not unusual. It's something that we see all the time. There are certain things that happen that we try to address in other ways, but it's not unusual that we may find someone, charge someone, and make allegations, criminal allegations against someone that has outstanding warrants or capiases or the like. It's just not unusual, unfortunately.
Is it unusual to have a mother and daughter both being prosecuted for murder at the same time? Mariah Thomas is her daughter, is Lillian Roberts' daughter. She's charged with in the 2 counts of the firebombing from December where they killed the 2 people.
We're just talking about this case today.
Prosecutor Worthy, this is an aside perhaps, just wondering when he went missing, there was an Amber Alert issued, but not the one that goes directly to the cell phone. And I know they did find the 2 suspects in Toledo. I'm wondering, just on the law, the legal side of it, would it be helpful to maybe look at the Amber Alert policy and what they would require to issue an alert? Because in this case, they had a description of the vehicle, not the license plate.
Frankly, that's something I've never thought of. Perhaps that is something that does need to be looked into. It's nothing I've ever thought about, frankly.
Prosecutor Worthy, there's no more questions on this. I know there's been a lot of violence involving kids these days getting their hands on guns. There was a couple from Redford that was just arraigned this morning
Yes.
because their child got a hand on a gun and shot himself. Is it important for you as a prosecutor to hold these people accountable, and that's why now perhaps parents are getting charged as well?
Well, it's critically important, and I don't know if you were at a press conference we had just days ago where we talked about the 8 cases where children have been harmed, injured, or seriously injured or killed as a result of obtaining a loaded, unsecured firearm. And just since then, as you mentioned, we had 2 more of these cases that we have charged this week, so which brings that total to 10. And I suspect that we're going to see many more. Charging these cases are not something charging these cases are something we've done before. It's not the first time we've done them. But when I looked at the alarming number of these cases that occurred, that's when I decided we wanted to pay attention to that. And I outlined for you, I don't know how many days ago it was, 10 days or so ago it was, some of the steps that we're beginning to take to make sure that we try to make sure this doesn't happen anymore. I talked about changes in the law. I've talked about contacting the heads of different health organizations about expanding the questions that are asked during the annual pediatrician visits and doing some real follow-up on those questions. I've already had some conversations with 2 of the heads of 2 major hospitals that we have in the area, and they're very receptive to the idea. In fact, have offered me some suggestions that I hadn't thought of myself. And so we're moving forward on that. As to legislation, it's going to take some time, but we're in the process of looking at other states and what they are doing. As I stated before, Michigan is one of few states that do not have a law that holds gun owners responsible for when children are seriously injured or killed when unsecured loaded firearms are found. So I would like a companion statute. It gives us more tools in our toolbox as to what we can do. And certainly, I don't think anyone would disagree with me. I don't think even the NRA disagrees that we should have responsible gun ownership, and that I don't think anyone wants to see these kind of shootings and deaths continue to happen. So we're taking another step out and trying to make sure we can get in prevention mode to see if we can stem some of these acts that these children are harming themselves with these unsecured guns. I didn't expect to see 2 more so quickly just after we announced it. All right.
Any updates on the Dearborn police shootings?
We're working on it.
Prosecutor Worthy, if you can indulge just one question on the Sanford case. You had mentioned Smothers waffling, going back and forth about testifying. There's been so many hearings that we're looking at some previous stories. There was also an effort to ask for some immunity for him to come testify. Your office opposed that. Why
Well, the one thing I'm going to say it again, the one thing we wanted to do was we were hoping that he would testify and give us something to, give something to the judge, not to us, give something to the judge to make his decision. But what I'm going to encourage you to do, and maybe you've already done it, is to read the lengthy opinion of Judge Sullivan that lays out his reasons for making the decision. So
And
that's,
to be fair,
no,
I'm sorry.
that's what we relied on.
I'm going to put in my
So-
story that they lived at 19700 Beelan, which was indeed down the street from the 19770 Beelan, the dog track for it. Do you want to, I'm going to put that because that is where they live. That isn't at their house. It's down the street from their house, as I indicated. Would you care to comment on that?
I've answered probably about
Okay, I don't want
27 of your
not give
questions.
you an
So
opportunity to
okay.
respond because I'm
All
going
right.
to put the fact that they didn't live where you said they lived.
Well, feel free.
Thank you, ma'am.
All right. So any other questions? Thank you. Thank you. All right, thanks, guys.
Oh, if you need the spelling of any of their names, you can ask them now. I want to say.
Ernest, is it E-R-N or E-A?
E-R.
Or is he also going to be arraigned at Petersburg?
Okay. All right. Thanks, guys.
Okay. Okay. Come back at the rest later.
Um,